SJC-13059, Patricia A. Fournier as personal representative of the estate of Emily Ms. Oschek. B, Mary Lou Sutters in her official capacity as Secretary of the Executive Office of Health and Human Services.
Okay, Attorney Green.
Good morning, Your Honors. May it please the Court, Assistant Attorney General Julie Green for the defendant appellant, Secretary Sutters. Thank you for the opportunity to appear in person today. In Daly v. Secretary of EOHHS, this court identified the possibility that an applicant for Medicaid benefits could exercise a power of appointment like the one at issue in this case in favor of a nonprofit nursing home, and that such an exercise could constitute a payment for the benefit of the applicant. In this case, Mass Health examined the specific terms of the trust at issue in this case and determined that such a theorized exercise of the power of appointment is authorized by the terms of this trust, and that such a payment would constitute a circumstance for which payment could be made for the benefit of the applicant, and therefore the trust assets in this case are countable within the meaning of 42 U.S.C. 1396P.
So counsel, what's the theory upon which there is a circumstance where the settler could have the benefit of the principal?
So the theory is that the payment would be, that the appointment would be exercised in payment for services rendered by the nursing home. So that could
how is that not in contravention of the trust instrument?
I'm sorry, in contravention of?
The trust instrument, which gives the settler a limited power of appointment for a nonprofit organization.
Because the trust instrument explicitly authorizes an exercise in favor of a nonprofit, but it contains no limitation for the purposes for which that exercise may be made. It does not limit the exercise to charitable or donative purposes alone. It also contains no limitation on exercise of the appointment for the benefit of the applicant. So for example, if you can see an example of such a limitation not present in this trust at addendum page 113 of the appellee's brief. It's a trust. It's a Board of Hearings decision regarding a trust where it quotes a trust provision, a power of appointment that says, in effect, but this power of appointment shall not be exercised to pay a debt of the grantor or in any way for the benefit of the grantor.
Isn't that exactly what's happening here, where there's a limited power to appoint in favor of a nonprofit, coupled with Article 2.1, which does not allow the trustee to appoint to use principal on behalf of the settler?
Two responses to that. First of all, as a technical matter, this trust does not contain any prohibition on the trustee using the trustee's separate distributive power in favor of the applicant. Many trusts do contain language like that, and I cited a number of them in my brief, including in the Hine case.
So you think that would be consistent with the trustee's fiduciary duty to execute, let's say, this hypothetical power of appointment in favor of the settler, despite Article 2.1? That wouldn't be a breach of the duty?
There's no breach of the fiduciary duty for two reasons. First of all, no action by the trustee is required here.
Well, who distributes the funds?
It would not be a distribution. It would be an exercise of the power of appointment, and the mechanism by which it gets exercised is as simple as a writing by the applicant, Ms. Oschek, stating, I hereby exercise my power of appointment in favor of
Myself.
In favor of such and such nursing home nonprofit, Inc. That would be effective to exercise this power of appointment. It requires no action by the trustee, but it would cause there to be a payment from the corpus of the trust directly to a nonprofit nursing home.
And who would cause that payment to happen?
So that exercise
Be automatically executed by the bank, or who would execute that?
There would likely have to be some additional implementing actions, but
by whom?
possibly by the trustee. I
Okay, so
agree
given that possibility, why is that consistent with Article 2.1?
It's consistent because it would be effectuating a power explicitly granted by the trust. There is no breach of fiduciary duty. If the trust doesn't bar the exercise of the power by Mrs. Maziaszek, then the trustee has no fiduciary duty to prohibiting the trustee from helping Mrs. Maziaszek to implement a power that she's expressly authorized to use.
So where is the express power of the settler to use this power of appointment, which is a limited power of appointment, on her own behalf for her own creditors to pay for her own nursing home?
The express power is limited to an exercise in favor of a nonprofit or charitable organization.
Right, but here there's a quid pro quo, according to the scenario that you're envisioning as Mass Health's lawyer, right? The quid pro quo is you provide services to the settler, and in payment of those services, the settler is going to, instead of paying you money, is going to give you this power, is going to give you the principal, right?
That's correct, because this power of appointment does not prohibit any type of quid pro quo.
And why do we not read into this limited power of appointment all the traditional trust law that would preclude that?
Because trusts fundamentally should be read in accordance with their plain language. This grantor, Mrs. Maziaszek, plainly knew how to draft the trust, so it effectuated her intent. She drafted a very broad power of appointment for herself. Obviously.
Well,
her
it's actually a
attorney-
limited power of appointment. I mean, it's only broad in the sense that you're suggesting that it could be exercised in a way that is precluded by traditional trust law under the traditional power of appointment, which is limited.
It is limited solely in the sense that the class of permissible appointees is limited. It must
Right,
be to a
and she's not
nonprofit.
one of those persons in that class.
That's correct, and she cannot appoint to herself.
Right, and so isn't she effectively appointing to herself under your hypothetical scenario?
She's appointing to a nonprofit.
In
And-
payment for services that she received.
And there's definitely a benefit to herself. I agree. I'm not disagreeing with your hypothetical. My position is that nothing in that power of appointment prohibits benefits of any sort. Nothing in the power of appointment limits the purposes or motives or collateral benefits that that the applicant may receive as a result of the power of appointment. Let me give some examples.
If the power of appointment read, so right now it reads, during our lifetime, we shall have the power to appoint from time to time, blank and blank, to any one or more charitable or nonprofit organizations. If it had added the sentence for charitable or nonprofit purposes, then this would be forbidden.
It would. If there were a limitation as to purpose, the outcome would be different.
So isn't that implicit in the first part of the sentence, that you're giving it to the charitable or nonprofit organization? It's not for, it's not for your purposes, right? It's for their purposes, isn't it?
It is for the benefit of the nonprofit, but in the theorized transaction that I'm talking about, there's clearly a benefit to the nonprofit.
So if she wanted to go to college, they could give it to the university as long as I'm giving you $50,000 as long as you take it to pay for my tuition. That would be fine too.
It would be fine because the power of appointment could have limited its uses and it doesn't. I'll give you a couple of other examples.
How about the following? She finds a nonprofit, says, I'm going to give you $100,000 as long as you give me $50,000 back. That's okay too?
I think that would be skirting the line that would start to look like a collusive exercise. But there are a lot of circumstances. I'm sorry, I didn't mean to interrupt.
No, go ahead.
Council, actually, could I follow up on Justice Kafter's question? What would happen if your scenario played out, but then the nursing facility or the care facility didn't apply it to the services that were being rendered to the settlor?
I think that would depend on the specific transaction that occurred with the applicant. So for example, she might have a claim against the nursing facility, the nonprofit, for, money hadn't received.
But then that implicates Justice Wendland's point then, that the only reason why the exercise of this power of appointment would be for the settlor's benefit. And isn't that directly in contradiction to the terms? Because if you're saying that if she exercises this right and that money is transferred to the nursing facility and the nursing facility does not apply that to the benefit that it's giving to her, that somehow now she's got a separate cause of action, doesn't that just answer the question that the only exercise of this power of appointment is for her benefit and that's prohibited?
Where I part ways with you is whether an exercise for her benefit is prohibited. The terms of this trust do not prohibit an exercise for her benefit. They could, and some trusts do. In fact, most trusts do contain terms. Excuse me, I'm having terrible problems with my map today. Many trusts do contain terms that expressly say that, and I've cited a number of cases that involved trusts that said exactly that. I think it's very significant that the terms of this trust do not contain any such prohibition. They could but they don't. If this court were to read the power of appointment as containing such an express prohibition on benefit of any type to the applicant, it would be reading terms into the trust that the applicant, the trust settlor, did not see fit to put there.
Do you know of any limited power of authority that has been read in the way that Mass Health wants it to be read?
No, I'm not aware of any cases raising this question or addressing it one way or the other.
But what about Pittman? Can you explain the difference between this and Pittman? Because it seems like Pittman prohibited the use of a limited power of authority appointment, to benefit somebody who was not among those to receive the benefit.
That's true. That's certainly the result in that case. And I would submit that this trust should be read differently for a couple of reasons. First, that the entire purpose for which the court read in that additional term that wasn't in the trust was to serve a purpose to serve a rationale that simply doesn't apply here. So in that case, the whole purpose of the additional unwritten prohibition was to vindicate the will of the mother and to prevent it from being abused by the son using the power differently than she had intended. Here, Mrs. Maziashek wrote the trust herself. She gave herself exactly those powers that she wanted to give herself and did not include any prohibitions that she did not want to include. And there's really no reason to be reading in additional terms that she herself did not see fit to put there. Second, the rule of Pittman is a difficult rule to administer because it requires the court to embroil itself in an inquiry into what were the settlor's actual motives when the settler exercised.
It involves determining the settler's intent, which is what one always does when one looks at a trust instrument. And you want to know what the intent was, and you want to be true to the intent. Here, it seems to me that read as a whole, the trust instrument may arguably have this intent of never allowing the settler to reach the principal. Article 2.1 says that, and the limited power of authority, if read consistent with Pittman, would preclude that as well.
I disagree that the trust indicates such an intent. I think another.
Where do you see a contrary intent?
Well, the express purpose of the trust. In fact, the express purpose of the trust in Article 1 states that the purpose of the trust is essentially to benefit the applicant. It talks about using the principle to allow the applicant that the purpose of the trust is to manage the applicant's assets and allow her to live in the community as long as possible. It is not an express purpose of preserving assets to benefit the beneficiaries of the principle. And that's an important distinction. And I think that distinction is also borne out in the fact that it does include a power of appointment that permits the applicant during her lifetime to dispose of the entire principal without regard for whether any principal is preserved for the children beneficiaries at the end of her life. Clearly, she intended to retain a significant degree of control over these assets and not to prioritize the legacy to the children beneficiaries at
Ms.
the
Green,
end.
before you run out of time, just from a different perspective, as we look at the any circumstances test, the charity's not going to be able to take this money. In the real world, this isn't going to happen. This is all theoretical, but the charity's not going to take a risk of losing their designation. They're not going to be able to benefit a private donor. So I understand all the good reasons to expansively look at the any circumstances test. There's huge public policy implications that your argument recognizes, obviously, with the price running out of control. But doesn't this just, it's a bridge too far, it just doesn't work. The charity's not gonna be able to take the money.
I think the charity could take the money. I recognize that this is an unclear area of the law, and the charity would probably want some clarity about what the legal result was at the end of the day. But if there were no other source of assets available, she entered the nursing facility with the understanding that, you know, her children would pay, and then they didn't, and then now there's a debt. I think it's entirely possible that a
Counsel,
nonprofit.
May I just interrupt for a moment? You said this was an unsettled area or an unclear area of the law. And then there's guidance needed essentially. Can you tell me, are there any other cases pending, or do you know have any other nursing homes accepted money this way or accepted funds from a trust like this?
Not that I'm aware of, no. I think this issue was first raised explicitly in a case in 2017 when the Daly Court identified this possibility.
Is the AG's charity division gonna approve this kind of transaction? Is there any guidance from the charities division saying that this is an appropriate charitable contribution? Because you guys are monitoring that as well, right?
My position is that there's no charitable contribution involved, so it wouldn't involve the charities division.
But
This
your
would be,
charities division has not rendered an opinion.
and it has not rendered any opinion, no.
Okay, thank you very much.
Thank you, Your Honor.
Attorney Neely.
Good morning, and may it please the court. My name is Lisa Neely, and I represent the appellee Patricia Fournier in this matter. This case is about Mrs. Emily Mashajek, who is now deceased, being denied eligibility for Mass Health benefits because she established and funded an irrevocable trust while she was still alive. In the trust, Mrs. Mashajek retained a limited power to appoint assets to charitable and nonprofit organizations only.
So
She
can
was-
you address counsel's argument that it didn't limit her power to charitable purposes, and that she could enter into this quid pro quo agreement with a nursing home that was a nonprofit?
Yes, Your Honor. I believe that when read as a whole, the trust instrument in this case needs to be read as a whole. And
Right, and so
clearly-
what your opposing counsel has said is that read as a whole, the purpose of the trust is to allow, as it says in 1.2, the management of assets and living in the community as long as possible, not the preservation of principle.
Well, I believe that clause 1.2 has also been read out of context because this, and it's not in contradiction with the preservation of principle. It just references management of assets. And if you look at Article 2.3, the trust states that the donor, Mrs. Mashajek, has the right to use and occupy the residence held in trust. So I don't view that as conflicting, considering that she can reside in the property that's in the trust for the remainder of her lifetime. And that mentions nothing about a distribution of principal to her. If you read the trust as a whole, I mean, it clearly, the principal has to be held until the termination of the trust, at which point it's distributed out to her children.
And that's, you're relying on section 2.1?
Yes, Your Honor.
Okay.
I don't believe that I believe that just by operation of law, the limited power means that the asset cannot be applied for the benefit of an impermissible appointee. And in this case, the quid pro quo transaction that my sister is proposing would be for the benefit of an impermissible appointee because it is for the benefit of Mrs. Masajic or her creditors. I mean, in this case, the nursing home would essentially be a creditor. They would be owed a debt. And under a limited power of appointment pursuant to established Massachusetts case law, a limited power cannot be used to
So
discharge.
what case law are you relying on? Is it Pittman that your opposing counsel has distinguished?
Yes, I am relying on Pittman.
So why isn't the difference that she points out between a self-settled trust and the third-party situation in Pittman relevant in our analysis?
Because that is just not the way the law in Massachusetts has been interpreted.
Can you be more specific, though? I mean, she's distinguishing Pittman on that basis, and you're saying there's this law out there in the ether. What law are you referring to?
I'm talking about the restatements of property. So the restatement first, second, and third of property has never distinguished between this power being operative in a self-settled versus a third-party trust. Pittman did not make that distinction at all. It was about a third-party trust, but it did not make that distinction. And in other jurisdictions, which my sister has relied upon in her pleadings, there have been specific statutes that state if the donor retains a limited power, that's going to cause the trust to be includable, so to speak. And here in Massachusetts, we just don't have that statute. And so I think one of the issues is that Mass Health in this case is possibly trying to, they have a policy objective and, that they're essentially should be seeking guidance from the legislature.
But are you saying in other jurisdictions, there's a statute and we don't have one?
Correct, Your Honor. And I believe in the case in Reed Brown's estate, which is discussed in the briefs and also in the Massachusetts Bar Association brief, there's just no such statute in Massachusetts. And the reason for that is clarity. I mean, you have individuals out there drafting these irrevocable trusts for a variety of purposes. It may be for protection of assets, which is authorized under the any circumstances test.
Could I ask you to address something else? Is it really an open question in Massachusetts whether or not a nonprofit can retain its status, yet accept the kind of quid pro quo contemplated by Mass Health?
I am not aware that that's an open question of law in Massachusetts.
In your mind, it's clear that the nonprofit would lose its status.
Correct, Your Honor.
And what do we rely on for that?
I believe I
'Cause
cited several.
We do have the AG's office, which monitors charities, suggesting that this is permissible. And we also do have our own statement in the DOE, which I take it you're going to ask us to walk back, right?
Well, I believe that the statement in Nadeau, it just offered Mass Health the ability to consider the possibility that this could render the corpus of the trust countable. And in Nadeau, Mass Health.
It's pretty direct. I mean, I understand it's dictum, and it may be incorrect, but we do have to confront that, right?
Yes, Your Honor. And, just a brief history of the Nadeau case, that commentary that was included in the decision was not based upon any argument made by counsel at those proceedings.
It's a question, not an answer.
Correct. It was a question, Your Honor. And when, and I know this was discussed in my brief, but in Nadeau, that matter or that specific issue was relitigated at the Board of Hearings, and Mr. Nadeau prevailed upon that specific issue again, and that matter was not appealed further. And then essentially it was like a snowball effect, and then trusts with this provision, the limited power of appointment to charities or nonprofits, the argument kept being raised by Mass Health repeatedly that this made these trusts countable. So that's kind of the origin of this specific argument that's being presented today.
It was a little more than a question though, wasn't it? I'm reading directly. Had Nadeau received care in a nursing home operated by a nonprofit organization, he could have used the assets of the trust, including his home, to pay the nonprofit organization for his care. It doesn't sound like a question.
I believe there was another sentence after or before that which said Mass Health can consider the possibility, and there was a remand direction.
Right, no, the next sentence goes, because approximately 1/4 of nursing homes are operated by nonprofits, it is appropriate for Mass Health to consider whether this possibility fits within any circumstances test.
Correct. So I interpret that as an invitation for Mass Health to consider the possibility of whether this would meet the any circumstances test, not a direction that this does meet the any circumstances test. And, you know, part of the issue with this case and how it has ended up here is that the hearing officer at the below proceedings interpreted that as a legal holding. And he essentially said in his decision, I credit the appellant's arguments regarding the limitations on powers of appointment and how they're to be used in trusts. But here we have a holding from the Daily Court. So I have to, I'm bound by that.
What is the best source of Justice Wendland's question? What is the best source for us to look at to determine that this would be an illegal charitable contribution? What should we look at to make that determination?
Well, I believe the best source are the restatement of property language that defines what an impermissible appointee is, and then possibly the Pittman case. And then, you know, to be quite honest,
there's no law from the charitable contribution area that makes this explicit, because you're asking us to look at trust law, which may be the right place, but I think we're asking a different question, which is, when we look at charitable organizations, would they lose their tax status if they accept? Is there some tax law that says that you lose your tax exempt status if you accept these kinds of contributions? Anything you're aware of?
there is, Your Honor, and I did cite several cases in my brief. If I can just grab, if you don't mind, I can just.
Isn't that, isn't it a matter of statutory law that in order to be a 501c, you have to abide by 501c, which specifically precludes donations of this kind of quid pro quo and retention of the status?
That is correct. It prohibits a charitable contribution from being used for the benefit of a specific individual. That is the basic concept there. So I believe the charity would be bound by that, and they could potentially lose their tax exempt status. But regardless of that, I think the primary issue to be resolved in this case is just concerns what the limited power of appointment is and how it operates in this trust document. And Mass Health acknowledges the difference between the two powers of appointment in their brief. They acknowledge what a limited power of appointment is and what a general power of appointment is.
Yeah, but I think Mass Health's position is that here the settler could have gone on to say, not only you may use this limited power of authority of appointment to donate principal to a nonprofit, and also not to inure to your benefit.
Well, I believe Mass Health is contemplating or asking this court to contemplate a scenario that's outside the four corners of the trust instrument.
I think it's the opposite. I think if I understand the argument correctly, is that in order to arrive to your position, we would have to read into the limited power of appointment this exclusion of self-interest quid pro quo.
I don't believe.
I'm not suggesting I believe that or agree with that position, but I think that's the position. And so I'm wondering what your answer is. Why are you reading that in?
There's no Massachusetts case law which says the limited power needs to specifically exclude the donor from benefiting. And I'm not aware of any case law to that effect. I think the way the common law has been interpreted over many decades is that a limited power cannot be used for the benefit of the donor.
But that would bring me back to my original question to you, which is, aside from Pittman, are you relying on anything else? And it sounds like you're relying on other jurisdictions, the restatement, but not any Massachusetts case law.
I am. There are several items in case law that I've relied upon. I believe that in the In Re Tosi case, the State Street Company versus Riser case, which I'm cited into my pleadings, which just generally talk about limited powers of appointment, mostly in the creditor-debtor context.
For self-settled trusts?
Correct, Your Honor.
So you can understand where the Attorney General's coming from here, though. We've got any circumstance test, that's expansive language, and we've got an area of budget that's hemorrhaging. And why isn't this a reasonable position that any circumstances really means even theoretically any circumstances?
Well, Mass Health is contemplating a scenario, a hypothetical scenario that's just not the way Massachusetts law interprets the use of limited powers of appointment. So they're contemplating something outside the bounds of traditional trust law and how it's been interpreted to satisfy this, to say this trust meets the any circumstances test, and therefore we can attach the asset of this trust. I mean, the any circumstances test talks about payments to or for the benefit of. It doesn't talk about hypothetical scenarios. And I think in this a Verdot case from New York, in which a limited power of appointment similar to the one here was analyzed, they talked about there's no evidence here of any collusion or that occurred. I mean, there's just nothing to indicate that this is going to occur in this case. And I also believe if you review the Hain case from the appeals court in 2016, they talk about there was a limited power of appointment in that case where it allowed the donor to appoint assets to their issue. And Mass Health raised a similar argument there that the issue could then turn around and give it back to the applicant for benefits. And what the appeals court said would be that would be completely gratuitous. There would be nothing compelling them to do that. So therefore it was outside of the bounds. And I think that is similar to what's occurring here. It's just a scenario. It's multiple steps in a transaction that's just not contemplated by the trust instrument here to satisfy policy objective of counting these irrevocable trusts. I mean, this isn't the first case over the last few years that's been argued about these types of trusts. This has been coming up very frequently. And I think it's clear that Mass Health wishes to deny these trusts and count them, due to, fiscal or policy concerns, but it's very important for the unity of trust law, even outside of the scope of Medicaid and long-term care planning, for these concepts to be interpreted equally across the board and not just make special exemptions for, for this type of scenario in this any circumstances test.
So I think that argument could go both ways, right? That those planning their estates should take into consideration the evolving nature of the law and maybe be more clear when they, for example, in Article 2.2, have a limited power of appointment to expressly state and not to inure to my benefit. I mean, why would that be a legal regime that would be unacceptable?
I don't think it's necessarily unacceptable, but I think it's a new interpretation Mass Health is presenting, that individuals that have been doing these trusts, and also in a variety of other contexts as well, not necessarily for long-term care planning, rely on the consistency of common law. And if there's no statutory or regulatory guidance about what is acceptable to Mass Health and what isn't, you're going to have scenarios like this where you have many different cases pending in lower courts, Board of Hearings, now here before the Supreme Judicial Court, where this provision is interpreted in different ways by the agency. And I think a resolution as presented by the MBA brief is if Mass Health wants this change, I think the legislature is the best way to go about that, because then it gives notice to individuals and in the Commonwealth desiring to do planning and, to their attorneys.
Well, I mean, I think a decision from this court would also give notice.
But I think a decision from this court interpreting the limited power to allow for payment for Mrs. Masajic's creditors to the nursing home and to go that extra step would go against the grain of what a limited power of appointment is, which is it can't
As set forth in the restatement, but no Massachusetts law.
Well, in like I said, the Pittman case about the impermissible appointee, I think that's the most on point. And there's just not a lot of case law about this specific transaction being presented.
Okay, thank you very much.
Thank you, Your Honor.